Ladies and gentlemen, the next speaker is James F. Kennedy. And Jim Kennedy is a partner, Osler, Hoskin and Harcourt, and in case any additional qualification be necessary to be on a panel of this sort, Jim has been an instructor for many years past in the estate planning and in the estate administration part of the bar admission course. He's lectured extensively in this area to legal groups, engineers, other professional groups in the continuing education series and in the Canadian Bar series as well. My problem in introducing Jim Kennedy really is that I know him too well. Our association goes back about 30 years, and in fact when we were both working in the summers for the same summer camp and sharing a cabin, I have until today not heard him speak on any legal subject except at his wedding, where he told the guests that the punishment for the crime of bigamy was 2 mothers-in-law. And despite that, he went on and had 5 children and married to Judy Cox, who is one of the most successful and beautiful models in this country. And I have asked him today, among other things, to please deal briefly with his own will that he made many years ago and has a unique feature too. In those days when I first knew him, his main interests in life were horses and women. We were both riding instructors at this camp, and his will has a clause that when he dies, his skin be pickled, cut up, and made into side saddles for women so he can keep in contact with his 2 great interests. So I'll give you Mr. Kennedy.
Thank you very much, Burke. Perhaps I should start off by making an announcement. There have been a number of people in the program today that have made some inquiries about the trailer which appears outside the east door of the building. It's dispensing information on birth control and venereal disease. I want to assure you that it has absolutely no connection with this program at all. Whether it has any connection with the bar admission course, I'm afraid you'll have to ask someone else about. I'd also like to apologize for inflicting you for the next little while with my rather nasal voice, but like Terry Sweeney this morning, I too am suffering from a cold. I tried to take some medication for it this morning, and like most lawyers, I took the pill before I read the label. On the label, after I had taken the pill, I discovered a statement along these lines: if this medication makes you feel drowsy, avoid any activity which requires alertness. I'm not sure whether this program qualifies or not. This seems to be the age of public disclosure. I guess the most recent example of that I can think of is the book that's just recently been published in the United States entitled The Brethren, which gives some inside views of the workings of the Supreme Court of the United States. Well, in keeping with this disclosure, I feel there are 1 or 2 things that I should disclose about the workings of the brethren who were responsible for organizing this program, in particular in view of Burke's comments initially. The first problem we faced was that Burke Doran was on the committee as a result of an error of law. The error of law was that he understood estate planning to be a subject that would give him some assistance in deciding where to plant the shrubbery on his farm. After we got him working on the proper course, and we presented our initial outline of the program that we proposed, Burke came up with some very, very strong objections. There were at least two matters that he felt that anyone who knew anything about estate planning would have included in a program such as this. And the first one was something on the Federal Estate Tax Act. And the second one was one of his favorite topics, the subject of the basic herd. For those of you that have questions along the same lines, these lectures are respectfully dedicated. Turning to shareholders' agreements, it's interesting that the Planning Committee didn't really give any guidance to any of the speakers on what we meant by recent developments. And we've had speakers talk about matters from the 18th century up to the most recent unreported decisions in 1980. I chose as my starting place the 1957 special lectures, which dealt with the subject of estate planning and were the last ones that did. When I looked over these special lectures, I discovered that there was very, very little in them dealing with the subject of shareholders' agreements. There was, of course, a remark in the comments by the life insurance lecturer, Mr. Deacon, and the only other thing I could find was a comment in a lecture given by Mr. A.J. Little, formerly of Clarkson Gordon, on a lecture he gave entitled Particular Problems of a Closely Held Corporation, where the following rather cryptic remark appears to be the sum and substance of his dealing with the problem. Quotes, "Some form of agreement or buy-sell arrangement is probably desirable in most cases." Close quotes. Well, 6 years later, there was an article that appeared in the Canadian Bar Review of the year, now that was 1963, written by Professor Huberman of the University of British Columbia Law School. He found the Canadian practice of the day to be quite deficient. He wrote, quotes, "The use of business life insurance and stock purchase agreements as effective corporate and estate planning devices has as yet not been widely employed in Canada. Life insurance underwriters in Canada have to some extent begun to explore the field." This is the part I like. "Canadian lawyers, on the other hand, are yet almost wholly unaware of the great potentials which stock purchase agreements funded with life insurance can offer as corporate and estate planning devices." The rather sad commentary on the leadership of the profession at the time. Fortunately, as may be seen from the proliferation of articles and reference materials now available, the situation has changed rather dramatically. And it's a good thing, too. The businessman with shares of a closely held corporation presents special problems for the estate planner. His holdings are seldom readily liquid. He is usually concerned about who will take the business over from him, and he's, of course, certain that he won't be able to run it nearly as well as he could. Most of his financial eggs are in the one business basket, and by reason of his hard work and the results of inflation, his success has produced a serious tax problem in the growth in value of his holdings, which he has insufficient assets other than the business to deal with. Upon his death, his executors or beneficiaries really only have three courses of action open to them. First, they can wind the business up. Secondly, they can continue to operate it. Or third, they can sell it for the best price and terms available. Unfortunately, it is only rarely that any of these three alternatives produce a really satisfactory result, and it may impose a burden on the executors or beneficiaries which they're just not equipped to handle. When our businessman is but one of several shareholders in a business, his problems may be compounded. For example, if he has a controlling or at least a major interest, the other shareholders may not be financially able to buy him out on any reasonable terms, and a potential outside buyer may not be prepared to accept less than 100% of the company. Dissolving the business may have serious consequences to the other shareholders as well as to him, and continuing under a state control may be equally unpalatable to them. If, on the other hand, our businessman holds a minority interest in the company, the majority shareholders may have no reason at all to want to increase their holdings by payment of anything approaching a reasonable price for his shares. They also might prefer to take their earnings out by means of salaries rather than dividends, which means that the minority holdings might not have any income produced on them at all, with all the consequences that that could have for our businessman or his executors. It is these and similar related problems that the estate planner has to wrestle with and attempt to solve for the businessman with the assistance of his other advisors. One of the tools which is almost invariably used today is a buy-sell agreement. And the subject of this paper is to examine some of the recent developments which have occurred affecting such agreements. The variety of matters which may be the subject of a shareholders' agreement has expanded enormously in recent years. For example, under Section 140 of the Canada Business Corporations Act, it is possible for the shareholders of a federally incorporated company to relieve the directors of their responsibilities under the Act and to assume those responsibilities themselves. Such provisions are beyond the scope of this paper, which will deal with some of the buy-sell aspects of shareholders' agreements only. You have heard from Don Drinkwalder this morning on some of the aspects of insurance funding of buy-sell agreements operating on death, and Ian Campbell has mentioned to you some of the special problems of valuation which occur, and I do not propose to make any further remarks on these two subjects. That will explain what you might have otherwise thought was a rather serious oversight in the outline which has been distributed to you. The Succession Duty Act of Ontario presented several tricky problems to the draftsman of a buy-sell agreement. You'll remember there were the provisions of Section 1R 14 and 15 dealing with undervalued agreements and options to purchase at less than the date of death value. There were the insurance provisions, tying the dutiability of insurance to the premium payment test and also subjecting to duty corporate-owned insurance which was not retained by the corporation. Fortunately, the draftsman is now relieved of these complexities, except in instances where the Succession Duty Act of Quebec or a foreign jurisdiction may apply. You, of course, will want to make sure that if you drafted a shareholders' agreement in the past, in which the value of the triggering event was in some way tied to a valuation for succession duty purposes, that you change this as quickly as possible, keeping your fingers crossed that nobody's going to die in the intervening period. This points out a very serious reason why you should not tie in a buy-sell price with a tax valuation. Quebec succession duties should only present a problem, as Malcolm Archibald mentioned to you, if the shares in question would be regarded as property having a Quebec situs, and in addition, either the deceased or a beneficiary is resident or domiciled in Quebec. There's, of course, also the problem under Section 3 of the Quebec Succession Duty Act, the accessions section, that Malcolm also mentioned, and we're all awaiting the results of the Ellett decision, which has been heard by the Supreme Court of Canada, but on which there has not yet been a decision. I was speaking to counsel in the Ellett case just 2 or 3 days ago, and he told me that the Supreme Court was frankly all over him in the decision, and he felt rather pessimistic about the result that was going to be coming forward. They're all obviously aware of the implications that their decision will have for the Quebec Succession Duty Act. Perhaps we might start our examination of shareholders' agreements by asking the rather fundamental question of whether they are valid at all, particularly so far as they operate on death, unless they're executed in a manner which is required for a will. There is no doubt that they're intended by the parties in that instance to operate only upon and after death in a manner similar to a will. Add to this the possibility that the buy-sell price may be fixed by the agreement substantially below the value of the shares apart from the agreement, thereby conferring a considerable benefit on the purchasing party, and you have quite a few similarities to a testamentary instrument. You can be sure that neither the taxing authorities nor the other estate beneficiaries will be very happy about the result and would be grateful for any opportunity to upset the scheme. You won't get much comfort either from looking at the definition of will, which is contained in the Succession Law Reform Act, because it doesn't really give much detail to it. Jarman summarizes the essential characteristics of a will in the following words. A will is an instrument by which a person makes a disposition of his property to take effect after his decease, and which is in its own nature ambulatory and revocable during his life. Buy-sell agreements normally are not unilaterally revocable, nor are they ambulatory in character, and it would appear that the absence of these two characteristics would lead to the conclusion that a buy-sell agreement operating on death is not a will, as contemplated by the Succession Law Reform Act. Now, in the outline which has been distributed to you, I've itemized a number of common inter vivos events that give rise often to triggering events in a buy-sell agreement. The only one, or the only two of those that I want to comment on at this time are the ones dealing with the desire to sell and physical or mental disability. Most businessmen are prepared to agree that if they are physically or mentally disabled for an extended period of time, they would want their business associates to be able to carry on the business without being hampered by their disability. And also the associates should be able to buy their shares at the same time. The difficulty usually arises with how you define the disability which triggers the buy-sell. Certainly, most seem to agree that if there is an order under the Mental Incompetency Act, that the date of this order is satisfactory. How do you deal with the question of the mental incompetent not so found, however? This situation may occur with greater frequency now that the Powers of Attorney Act 1979 has come into effect, under which it is possible now for a power of attorney to be exercised during the subsequent legal incapacity of the donor of the power. You'll be hearing more about this statute from Michael Jameson tomorrow. One possible method of dealing with the problem is to provide in your agreement for the certification of incompetency by one or more duly qualified medical practitioners. Physical disability is often also dealt with in shareholders' agreements. It may be it may be dealt with, rather, by medical evidence of the same sort, and is usually related to the inability of the individual to carry out his usual full-time employment with the company after a waiting period of an agreed duration. Unlike most buy-sell events operating during the lifetime of the shareholders, disability events, whether mental or physical, may be funded by a lump sum payment from a disability insurance policy, as you heard from Don Drinkwalder this morning. Although a disability payout policy of this sort is somewhat more expensive than the traditional types of disability insurance, it may be something which your clients would wish to investigate. If they do obtain disability insurance of this sort, it is obviously vital that the disability event as it's described in your shareholders agreement has to agree with the disability as defined in the insurance policy, and the disability buyout would only occur upon receipt of the insurance proceeds. Now, what about trying to handle the situation of shareholders simply wanting to sell? Certainly a common feature of every shareholders agreement is that the shares cannot be disposed of except in accordance with the terms of the agreement. What then of the shareholder who wants out? Unless the agreement has some provision to deal with this, the shareholder may be locked in until some event occurs which causes the buy-sell provisions to operate. Often an agreement will provide a reduced value buyout in these circumstances, perhaps combined with a right of first refusal if the shareholder can produce a buyer who is prepared to purchase at a higher price. In companies with larger numbers of shareholders, it may be possible to structure a trading system among the shareholders. The system would be operative on the basis that if someone wants to sell their shares, they would tender them to one of the officers of the company who would offer them at a determined price at regular intervals among the other shareholders. And any shares that weren't purchased in this manner could either be withdrawn by the shareholder or could be left with the officer to be offered at the next regular interval. Where the shareholdings in the corporation are such, for example, a 50-50 shareholding, are such that the expulsion provisions of the agreement cannot be used to resolve fundamental differences among the shareholders, or where there are no such provisions, the only solution where the shareholders simply are not prepared to continue in business together may be for the corporation to be wound up and its assets distributed unless the shareholders can agree on some sort of a common sale provision. To deal with this possibility, many agreements provide so-called shotgun provisions, or where larger numbers of shareholders are involved, private auction clauses. The typical shotgun clause is a type of put-call where one shareholder may put his shares to the other at a price and on terms fixed by him. And the failure of the others to buy gives rise to an obligation on their part to sell their shares for the same price and terms as was offered to them. You will find, if you haven't already, that drafting a clause of this sort for more than 2 or 3 shareholders becomes quite difficult, and in those circumstances you may prefer to have your agreement provide for a private auction to be held in which all the shareholders obligate themselves to submit their shares for sale to the highest bidder. One of the problems that you will have to look at very carefully in structuring an inter vivos buy-sell arrangement is the problem of associating otherwise unrelated corporations. This can occur by the operation of paragraph 251(5)(b) of the Income Tax Act. Under this section, a person who has a contractual right to acquire shares, whether exercisable immediately or in the future, or whether absolutely or contingently, is put in the same position as if he owned the shares, unless his rights only arise upon the death of an individual. The operation of this section can result in some extremely awkward tax consequences if the shares which the shareholder is given rights over, when combined with his own holdings, would place him in a control position. It may not be immediately obvious whether what you are providing by contract is, quotes, a right to or to acquire shares within the meaning of the section. 2 interpretation bulletins issued by the department may be of some help to you in resolving this matter. In IT 419, there's an indication that the department does not regard a right of first refusal as within the section. and probably the usual shotgun and auction clauses are also not included. On the other hand, IT 64R makes it clear the Department regards the holding of an option exercisable inter vivos as clearly within the section. Funding of an inter vivos purchase arrangement can also be difficult. Except in instances where the buy-sell occurs on disability, insurance is not available, and the private resources of the shareholders may be limited. Similar problems may also be encountered on death funding, where no insurance was taken on the life of the deceased shareholder or where he was uninsurable. In these circumstances, it may be necessary to have a payout provided over an extended period of time, with or without interest, as the shareholders agree. It may be possible to keep the value of the shares low by means of dividends or bonuses, or to require either the shareholders or the corporation to contribute to a regular sinking fund, possibly using some sort of a tax-deferred plan. In instances where one of the shareholders is uninsurable, it might be desirable to have the other shareholders or the corporation contribute the maximum amount of insurance premiums that would have been payable had he been insurable to a separate fund. Bank borrowings are, of course, also a source, and there seems to be no question that the interest on monies borrowed by shareholders for this purpose would be deductible. There may be some question about the deductibility of interest borrowed by a corporation to purchase the interest of one of its shareholders, unless the purchase price can be categorized as the substitution of debt capital for equity capital. Now, next in your outline, I've indicated that I'm going to make some remarks on the subject of undervaluation. I'd like to skip over that, if I could, to the subject of corporate purchase versus shareholders' purchase. Traditionally, the buy-sell rights and obligations in a shareholders' agreement have been among the shareholders only. In recent years, however, the corporate legislation of many Canadian jurisdictions has been amended to overcome the general prohibition at common law against a corporation purchasing its own common shares. The result of this is that where the corporate law permits, it is now possible to have the corporation as the buying party in a buy-sell agreement. What are some of the considerations to be taken into account when considering the two alternatives? First, the applicable corporate law must permit. That's rather obvious. Before making a corporation a party to a buy-sell agreement as purchaser, you must satisfy yourself that the relevant corporate legislation permits this, and if so, subject to what terms? Federal corporations to which the Canada Corporations Act continue to apply do not have the power to purchase their issued common shares. The same applies in some provincial jurisdictions. Federal corporations to which the Canada Business Corporations Act applies have the power to purchase their issued common shares unless that power is limited by their articles, and a similar provision is contained in the draft Ontario bill to revise the corporate legislation of this province, which is currently under study. Both the Canada Business Corporations Act and the new Ontario bill contain sections providing that a contract by a corporation to purchase the shares of a shareholder may be specifically enforced against the corporation, except where the purchase would violate the financial tests contained in the statutes. The Business Corporations Act of Ontario does permit a corporation to purchase its issued common shares, but only if it is specifically authorized to do so by its articles, and it may, of course, be necessary to get an amendment to its articles to include this clause. One problem which might be encountered in a corporate purchase arrangement is that both the federal and Ontario legislation prohibit shares from being purchased at a time when the corporation is insolvent, or if the purchase would result in it becoming insolvent, as defined in the Acts. This might well be the case if the corporation had been traditionally financed by shareholder loans rather than equity. Assuming that you are satisfied that the corporation may purchase its own shares and may be a party to the buy-sell, the tax results which are produced are quite different, and the requirements of the shareholders will have to be carefully considered. In an arm's-length transaction, a purchase by the other shareholders will normally produce a capital gain or loss for the selling shareholder, depending upon whether his adjusted cost base for the shares is above or below the purchase, the purchase sale price. The price paid by the buying shareholders, on the other hand, will be their cost of the shares and will be averaged with the cost of the other shares in the corporation held by them. The selling shareholder, if he is living, may purchase an income averaging annuity contract to relieve the tax bite on his capital gain, and may also claim a reserve under the Act for any proceeds which are not due in the current year. In a corporate repurchase arrangement, on the other hand, under subsection 84(3) of the Income Tax Act, the corporation is deemed to have paid and the shareholder to have received a dividend equal to the difference between the purchase price and the paid-up capital applicable to the shares. This means that if the shareholder sells the shares for $100 a share and they have a $1 paid-up capital, the corporation is deemed to pay, and he is deemed to receive, a $99 dividend and a $1 return of capital per share. This applies regardless of what his adjusted cost base for the shares is. The shareholder also has made a disposition of property as defined in Section 54 of the Act, and under paragraph 54HX may deduct the deemed dividend from his proceeds of disposition. This will produce a capital loss if his adjusted cost base for the shares exceeds their paid-up capital. If, in our example, the shareholder's ACB was $25 per share, the transaction would produce for him a $99 dividend, a $1 return of capital, and a $24 capital loss per share in the year the transaction occurred. No reserve can be claimed by him for any of the proceeds that are not payable in the current year or payable in cash. You will note in this example that our selling shareholder has lost the ability to treat his ACB as a return of capital, which he would be able to do in a sale to the other shareholders. Unless he is able to use the capital loss immediately, this may be a serious result for him. For the continuing shareholders, their respective interests in the corporation will remain unchanged, except that the proportions, of course, will have altered. They will not have the benefit of any step up in the cost base of their shareholdings, which may increase their own tax burden on a subsequent disposition. Where a corporate repurchase occurs on death and is funded by life insurance owned by the corporation, a complete elimination of taxes for the estate can occur if the corporation is a private corporation, as defined in paragraph 89(1)(f) of the Act. This result occurs as follows. On the death of the shareholder, the insurance proceeds in excess of the adjusted cost base of the policy to the corporation will form part of the corporation's capital dividend account as defined in paragraph 89(1)(b) of the Act. On purchase of the shares, a dividend arises which the corporation may elect to be payable out of its capital dividend account in accordance with subsection 83(2) of the Act. In that instance, the dividend is not taxable in the estate of the deceased shareholder. You should note that the entire amount of the dividend must be elected to come from the corporation's capital dividend account, and accordingly, if the insurance proceeds are not sufficient for this purpose, a two-stage purchase will be required. From the estate's point of view, a disposition of the shares at fair market value will occur on death pursuant to subsection 70 brackets 5 of the Act, which will produce a capital gain if the fair market value of the shares exceeds their adjusted cost base. Assuming that the purchase by the corporation takes place within the first estate year, subsection 164(6) of the Act would permit a loss on disposition to be offset against the gain occurring at death, and as noted above, the deemed dividend may be deducted in determining the proceeds of disposition under the Act, even though it is a tax-free dividend. From the standpoint of the remaining shareholders, of course, in addition to not being able to step up the cost base of their shares in that sort of a transaction, all of the corporation's capital dividend account will have flowed to the benefit of the deceased shareholder's estate, and they will derive no benefit at all from it. This, of course, may be a very good reason for requiring the corporation by contract to make the election to have the dividend come out of its capital dividend account. And that may be a reason why you're very happy about the fact that the agreement may be specifically enforceable against the corporation. One matter which has been receiving some consideration recently is whether it may be possible to transfer shares subject to a buy-sell agreement to a spouse or a spousal trust and have an accumulated capital gain taxed in the hands of the spouse or trust rather than in the estate return to the date of death under subsection 70 brackets 5. The reason, of course, that this would be desirable is that an estate cannot purchase an income averaging annuity contract, whereas the spouse could. In order to have the benefit of the spousal rollover under the Act, the property in question must become vested indefeasibly in the spouse or trust within 15 months from the taxpayer's death. Can property which is subject to a buy-sell ever qualify for this treatment? Well, there's a question, of course, as to whether the vesting indefeasibly of a concept which is a fairly familiar trust concept ever really applies suitably to this sort of a situation. However, the tax department has taken the position that it will not permit a rollover to the spouse in those circumstances. Although the tax department are somewhat unsettled in their interpretation of these provisions, and I understand that there is going to be an interpretation bulletin that will be issued by the department fairly soon, which you might want to have a look at. To avoid this result, namely that they can't get the benefit of a rollover, some taxpayers are trying clauses in their buy-sell agreement permitting the shares to be transferred to the spouse without being subject to the buy-sell obligation, and having the spouse enter into some sort of an obligation herself to sell the shares if she becomes the owner of them. In my view, this sort of a provision runs into the same problem with the tax department, and I understand that they do not regard that type of a provision as entitling the holder to a rollover. They may well be prepared to consider some sort of an arrangement whereby the shares are not immediately subject to an obligation when they pass to the spouse, but perhaps she has some sort of an option exercisable over a period of time in which she can require the continuing shareholders to purchase the shares if she wishes. The tax department would take the view in that instance that there isn't an obligation to sell that she has, but a right to sell, and that may be possible. Insurance to fund a buy-sell agreement may be owned either by the corporation or by its shareholders, regardless of who has the obligation to purchase. If the insurance is owned by the corporation, the value of the insurance proceeds may increase the value of the shares to be acquired, whereas this will not, of course, be the case if the policies are owned by the individual shareholders. Premiums paid for corporate-owned insurance will not be a deductible expense to the corporation unless the policies are required in connection with current borrowings of the corporation and the other requirements of IT 309R are satisfied. The payment of the premiums by the corporation will, however, not be regarded as a taxable benefit to the shareholders unless the corporation is paying the premiums on a policy owned by the shareholders. In this connection, a recent court decision of Mr. Justice Mahoney of the Federal Court Trial Decision should be noted. In Green Acres Fertilizers versus the Queen, he held that insurance premiums paid by a corporation on behalf of its shareholders were not a deductible business expense of the corporation, even though the amount of the premiums that had to be paid were taxable to the shareholders as a benefit conferred on them. I understand that the case is currently under appeal, so that may not be the final word. If it is the final word, it's an obvious instance where you must make certain that you increase the amount of remuneration to the shareholders and permit them to pay the premiums themselves. Finally, I would like to mention briefly two somewhat troublesome provisions of the Income Tax Act. Section 55 is one of the anti-avoidance provisions of the Act, and it provides as follows. For the purpose of this subdivision, where the result of one or more sales, exchanges, declarations of trust, or other transactions of any kind whatever is that a taxpayer has disposed of property under circumstances such that he may reasonably be considered to have artificially or unduly reduced the amount of his gain, increased a loss from the disposition, or increased the amount of his loss, the taxpayer's gain or loss, as the case may be, from the disposition of the property shall be computed as if such reduction, creation, or increase, as the case may be, had not occurred. It has been suggested by at least one writer that the entire elimination of taxes occurring on the death of a shareholder where there is a corporate purchase funded by life insurance may give rise to a threat of attack under Section 55 on the basis that the shareholder has artificially or unduly reduced the amount of the gain. The Tax Department is currently studying the circumstances where it will consider applying Section 55. However, my understanding from discussions with tax officials at the present is that they are not considering applying Section 55 in this situation. I am encouraged by this response on the basis that although the transaction may produce a beneficial tax result for the estate of a deceased shareholder, there may be substantial disadvantages to the surviving shareholders, and in any event, the result is produced by well-recognized provisions of the Act applied in normal business transactions where, in no sense, should there be regarded as being an artificial result produced. The second section I want to draw to your attention is subsection 85(4) of the Act, which should be considered by you when a corporate repurchase is proposed from a controlling shareholder, but in circumstances where he will remain in control following the transaction. The effect of the section is to deny the shareholder use of any capital loss on the transaction in the year in which it occurs, and to increase the cost of his remaining holdings by the amount of the loss. Although the applicability of the section to a corporate repurchase might be questioned, it is understood that the Department may regard it as applicable, and accordingly your planning should take this into account. The rationale for questioning its applicability is based on the fact that the section is triggered upon a disposition of capital property to a controlled corporation. In the normal corporate repurchase arrangements, the shares are canceled and disappear, leaving nothing in the hands of the corporation that it could be said to have acquired. Well, ladies and gentlemen, I see I have run out of time. I do have some notes on the subject of the undervalued buy-sell agreement, and they will appear in the printed material. Thank you very much.